Today we will talk about the environmental laws, and as you can see the title, the environmental laws, when they started some 35 years ago, and with the time they have gone and become very stringent, and it almost cover all aspects of our life, and we have both responsibility towards the environmental laws and the obligation, as well as we have certain rights. So we will go through the journey, which is basically the historical perspective to today's what conditions and what situation is there for the environmental laws. We will discuss that, and the title is Infancy to Stringency. If you look at the first slide, the question comes up as to why we need the laws. When we understand the system of the environmental pollution or environmental propagation of the pollution, transport of the pollution, we can say that three things which are happening. There is a source, there is a transport mechanism, whether it could be water pollution or air pollution, does not matter. The pollutants are transported through the medium, and there is a receptor. What I mean by the receptor are the people, the ecology that is affected. So there are three components of environmental system, whether it could be water pollution, air pollution, soil pollution, noise pollution, but there would be three components. Source is transport of the pollutant and its effects. So when the effect is so severe as the people tend to suffer because of the pollution, well, we need to do the control, and that is the direction of the control. And where it is controlled, for example, industry is causing pollution, so the industry must control the pollution. But sometimes saying is not enough. Okay, we may ask in the industry to control, but there has to be certain rules, regulation, so industry is duty bound to control the pollution. So we define what is the receptor. It could be the ecology and the people. And when we don't need the laws, if there are, like for example, if voluntarily the industry or the citizens or the people who are running the industry or running other pollution activities, they control the pollution on their own, then we don't need so many laws. But obviously the certain laws are required for the pollution control, and that has come through the societal response. As a society tend to ask for more and more pollution control, so then the environmental laws become very important component of the legal enforcement. So laws are through the parliament, that we can see that our parliament will make the laws, and there will be a system or there will be a body, there will be a mechanism to implement the laws. And in addition, the laws can be the national laws, as we will see some of them, and there could be international laws that we have to follow, and there could be treaties. There could be treaties between the two countries, or there could be the treaties amongst many countries or several countries. So, and then there could be protocols that we need to follow. So we will go through this journey in this lecture, and so we move to the next slide and look at the perspective about why suddenly there was a need for the environmental laws. We look at the history. There has been air pollution episodes have been reported. For example, suddenly because of the poor weather conditions, dispersion was poor, there has been many episodes which caused very high level of pollution, and that resulted in several deaths, injury, and there could be some accidents as well. So there's little examples I am giving here. Meuse Valley, Donora in Pennsylvania 1948, Poza Rica in Mexico 1950, London smoke, the very famous, and we'll little bit discuss about this, was in 1952. Several thousand people died because of the pollution problem in 1952, serious problem. And similarly in Japan in 1956, there was a pollution caused because of the methyl mercury pollution in the Minamata Bay, and that resulted into the severe injuries and the damage as well as the deaths. That was in 1956. And then also again in Japan, as the industries were growing in 1959, there was many people suffered from asthma, and in fact that asthma became famous, and the asthma got the name itself is Yokkaichi asthma. Yokkaichi was a place or a city in Japan. It's obviously if such a situation exists, we need to control the pollution, because the basic fundamental requirement or fundamental objective or the fundamental purpose for the pollution control engineers is to provide good and better public health to the people. So the second thing what you are seeing here on the screen, okay, these are mostly the responses to the environmental problems. So what were the responses? People tend to form the regulation. For example, the Clean Air Act was in response to 1952 London smoke. Water quality conservation law came in Japan in 1958. US federal air pollution legislation came in 1985. US EPA, a very important agency which does a lot of research and makes environmental laws, was formed in the United States in 1970. And also in the US again, Clean Air Act in the United States was amended in 1990 to account for pollution control even for the very other toxic compounds as well. So this little history we see that the mankind has been responding, the governments have been responding to the pollution. So let's see, this was a little historical thing what has happened in certain countries in the world, but let's see what exactly had happened in London smoke. You see a picture on your screen. You essentially see it was during the month of early week of December, that was in 1952. This was the, see here, this suddenly during the 3rd or 4th of December the pollution started rising. That you can see the green green line or the green graph, that was the sulfur dioxide, as you can see here. Okay, so both suddenly in London sulfur dioxide started going up, so was the smoke, the dot you see here, and the levels of both of them as you see on this side screen. Okay, that at the peak time it was like 2 milligram per meter cube of sulfur dioxide, which is very, very high. And you see it started affecting the people, and the red line what you see is the number of deaths, and number of deaths is given on this side. Okay, and there was this was a normal death rate, okay, per day in the London city, and then you see because of the pollution people started suffering, and it really caused the death apart from the injuries. And this is a picture taken from the London smoke from the BBC site, and then you can imagine like how pollution can cause very serious problems. So we need to control, and we have to have a legal system that would be enforced, and so industries need to follow, the individual people have to follow, the vehicle owners have to follow how to keep their vehicles clean. So these things become very important. So this lecture today is for the environmental laws. Let's see what is environmental laws in India, then we'll discuss a journey through past and what are the laws that we have today. In the constitution, every citizen, okay, need to do certain, they are duty bound to do certain things as per the article 15G that states for citizens of India is, it shall be the duty of every citizen of India to protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for the living creatures. So that's, we all are duty bound about to keep the environment clean. It's not only that every citizen is duty bound, the constitution also cast a duty on the states. So every state, as per the article 48A, which was 42nd amendment, it cast a duty on every state in the directive principles of our constitution. The state policy for taking the steps for the protection and the improvement of the environment. So state also need to do everything what it takes to clean up the environment for the better public health and a better living, which is in unison with the environmental conditions. So how the government acted onto the whole thing? What's in the 4th 5-year plan, that was first time the environmental pollution was talked about in India. So the environmental dimensions and planning and development was considered. They said, well, we can't leave the environment alone, and so in the planning process, in the development process, the environment should come. In the same during the same period, Pitambar Pant Committee was formed to prepare the India's country paper on human health, as I have written here and you can see on your screen. And then after that a committee was formed, which was a very important committee when it came to the devising and developing the environmental laws in the country, was the National Committee on Environmental Planning and Coordination, that was formed in 1972. And a very historical conference was held where the state head of many countries, they participated, and then they discussed as to how all over the world environmental protection should become a law and how to go about this one. So the extremely important conference was held that is called UN Conference on Human Environment, and that was held in Stockholm in Sweden in 1972. And that is what the basic thing that came out from that conference was preservation of the natural resources and the preservation of environmental quality, both the resources as well as the quality. This interesting thing that came out from the conference was very interestingly known as PPP principle, or it's called the polluter pays principle. So if you are polluting, I mean, you got to pay for it. So you can't get away by polluting scot-free, and you need to do something about this. So in fact, it was the follow-up of the Stockholm conference that Government of India, our government, decided to enforce certain laws. So first law that came into, which was exclusively for the environmental control, that came into being in 1974, and that act which, or the law that came into being, was called Water Pollution Prevention and Control Act 1974. In fact, under this provision of the law, state pollution control boards and central pollution control was formed, so that the environmental laws can be implemented when we have a mechanism to implement the environmental laws. That was in 1980. Department of Environment was formed, and by the time the work of the Department of Environment grew so much as that in 1985 the Department of Environment was upgraded to full-fledged ministry at the Government of India. So this is a little brief history more of the as to how the government institutions thought about the environmental the problems and how they acted onto this one. Well, we will try to get the most specific thing. Here there are the three main bodies in the country which deals with the environmental pollution and the environment in general. Okay. At the central government level, we have the Ministry of Environment and Forest. Again, at the central level, we have the Central Pollution Control Board, and at the state, which implements the environmental law on pollution control, is the State Pollution Control Board. What you can see here is the environmental policy and planning is done at the central government level. Central Pollution Control Board is an advisory agency to the Government of India. As you can see here, as I am trying to underline, advise the central government on the matters concerning prevention, control and abatement of water and air pollution. Similarly, the State Pollution Control Boards implement the laws in the state. Let us also quickly see what kind of mechanism these have. So these are the mechanism for the pollution control in India. What we have the central government at the federal level, okay. We have the state government at the state level. So at the central government level, we have the Ministry of Environment and Forest. Under that, there are many agencies and many other organs the ministry has to deal with the pollution, but the important thing is the Central Pollution Control Board, which is concerning largely with the pollution control, because environmental aspects, there are many aspects of the environment and pollution control is one of them. So we will focus here is that of the pollution control. The Central Pollution Control Board is an advisory body for Government of India, and it also has its general offices spread all over the country. Similarly, at the level of the state government, there is State Department or State Ministry of the Environment, that is here. It also has a State Pollution Control Board which interact with the state level ministry, and it also has the regional offices, as you can see here. And the State Pollution Control Board and the Central Pollution Control Board has a very close link, okay, and then they interact on the environmental laws and implementation and the enforcement of the laws. So this is in very brief, this is the mechanism of the enforcement of environmental laws concerning pollution control in the country. Let us quickly go and see there are many environmental laws that we need to understand, and we need to follow. You could be an industrialist, you could be ordinary citizens using the environmental resources. So there is a duty, there is a law for everyone. So probably it's little difficult to go through all the laws as you see on the screen, but the first law or the act that came was in 1974. Okay, that's called the Water Act, or the Water Prevention and Control of Pollution Act, that came into being in 1974. Some of the laws and rules we'll discuss as we go by in this lecture, and it will become more clear. But of course, environmental laws is such a subject in itself that it's probably difficult to cover through one lecture. So briefly we'll going over to certain issues, and these laws can be checked at the website of the ministry or of the Central Pollution Control Board if you need to go into the details. Okay, so we'll discuss a little bit about the Water Act that came in 1974. Essentially it focused on to the control, abate and prevent water pollution, and to preserve as well as restore the national water quality. So one of the major objectives set in this Water Act 1974 was to develop the water quality standards. What we mean by the water quality standards is the standards of the water quality in terms of the various parameters which should be what kind of water quality should be in the river, the lakes, the groundwater, and other environmental resources. So the objective was to set the standards, so that once we have the standard, then we can compare the things and can decide what action needs to be taken. Similarly, the keywords was polluter pays, okay, command and control, end of the pipe treatment. That became the focus for all the industries, and in fact even for the municipal supplies. Wastewater is generated in each city, and that needs to be controlled. And why we call it end of the pipe treatment is that when it is discharged, when it is about to be discharged into the water body or onto the land, there must be some treatment done. So that is called end of the pipe treatment. Okay, when we talk about the responsibilities, that is responsibility largely which I am referring here is to the industries. Let's write that one. Okay, every industry which is water polluting should obtain a consent. That's very important word. Before even the industry is going to start the business, before they are even going to put their foundation stone, what is required is that they obtained a consent, or in short form I can say a no objection certificate that industry can certainly come at the place where they intend to come. And in the when they are getting such kind of NOC, as I have written here, no objection certificate, they need to demonstrate as to kind of technology they have. It's a clean technology. They have to demonstrate the wastewater or that would come out from the industry will be properly treated, and it will not have the adverse impacts onto the receiving water body. So that's very important, that even before the industry it comes up, they need to take a permission, they need to take a consent, so that it is right in the beginning before the industry comes up, it is kind of guaranteed that industry will be an environmental friendly industry. So that's very important step. So legally all the industries which are, or all the people who are planning to have an industry, they rather go to the proper authorities and provide enough information that their industry is a clean process and it will not cause any harmful impact on the receiving water bodies or receiving the environment or to the people, and then they can get a go ahead and then they can start construction. Well, it doesn't end there, because once the industry is ready, before the production can start, they must obtain another consent, okay, and that consent is called consent to operate. Okay, that's specified under section 21. And when the industry goes asking for the consent to operate, because essentially what the industry is saying that, well, our industry is ready, or we are about to start the production, or we are about to start the operation of the industry. So in that case they again need a consent or permission from the government, and the government can put or lay down certain conditions, and those conditions are called the consent conditions, okay, especially on the discharge standards as to how much is the water quantity that you can discharge and how much is the pollutants that can be allowed to discharge, because it's in certain cases it may be possible to have the zero discharge or zero pollution, but certain industries, you know, they will be using a lot of water, and zero discharge and zero pollution sometimes can be very, very difficult, although one has to try every time to improve the situation. And then this consent thing, which I am trying to emphasize more and more, is the consent thing is not just one time business. Consent needs to be renewed every time within that certain time frame specified by the authorities, so that there is a continuous improvement in the functioning of the industry as far as the pollution is concerned, because, well, the authorities can tighten the standards, the authorities can say improve certain things, and that becomes a renewal mechanism for the consent, that it could be one need to renew. It depends on the authorities. It needs to be reviewed for 1 year, 3 years, 5 years, 10 years, depending on what kind of situation the person or the industry is in. So you get an idea as to the industry needs to take a consent, or needs to take a permission, or needs to take an NOC, which stands for no objection certificate. And sometimes even the NOC simply is not enough. They need to go something called EIA. That stands for environmental impact assessment. That is, in fact, is even detailed study of the impacts of the pollutions or the emissions and other activities on the environment as a whole. Okay, there are certain punitive measures. Very briefly will be specifying. Non-compliance, suppose the government has given the consent, and within the consent there are certain conditions which industry need to follow. If they don't, it can attract punitive action from the government, and there could be certain punishments that are incorporated in the law. Apart from that, it is simply not enough to say that the punitive measure. The industry also has certain rights, and why not? And these rights will include notice of inspection. If suppose somebody wants to come and inspect, so formal inspection, then they need to take certain, they need the information, the industry will need information. There is something called deemed consent. That is an important concept. Okay. Suppose the industry applies for a consent, and within 4 months there is no reply from the authorities, then the consent becomes automatic, and it becomes deemed consent, and it becomes unconditional consent. The industry also has a right to appeal if they think proper justice is not done to them, or the conditions have been very stringent, or something cannot be justified. They can appeal to an appellate authority that is again created as per the provisions of the Water Act. And then there are the opportunities for them to file the objection against, suppose industry is directed the closure, then they can go to the proper authority to say, well, the closure is not quite right, or they can explain the situation, and then proper action or no action can be taken as far as the closure is concerned. So these are the mechanisms and ways in which the Water Pollution Act is being implemented in the country. Well, we move on. Similarly, there is another provision in the Water Cess Act. That Act came in 1977, as you can see here. The purpose of the cess, or the cess means here basically essentially a small levy or charge on the amount of the water consumed. Sometimes there is a confusion as whether it is water consumed or water or wastewater discharged. So here essentially we are talking on the water uses. Okay. So objective here is not to collect the money, okay, but objective is that if you are charged certain money, you will have the you will try your everything best to conserve the water, because there's something like electricity, you pay for the electricity. So here also you are paying more and more for the more and more water uses. So there will be automatically there will be ways and means the industry or the person will think about how to minimize the water uses, and also this becomes additional resource for the pollution control boards. Responsibility for the responsibility and obligation for the industry. let's write in the bracket industry. Okay, they need to file a return, okay, file water cess return, similar to what we file a return to the income tax. So similarly, industry need to file a return on the water cess, okay, and that the deadline is May 15. They also need to provide the water meters so that we know exactly how much the water is being consumed. Even if somebody is not using the water from the lakes or from the river, even if they are using the groundwater, okay, the groundwater also come in the ambit of Water Cess Act. So you can't say, well, I'm not using the resources in terms of the river or lakes, but again the groundwater is not the sole authority, is not the sole resource that you can use independently. Groundwater is there for everyone to use. So even if somebody is using the groundwater, this comes under the ambit of Water Cess Act. And access to the relevant information and inspection that the authorities can ask for. The rights, well, rights for whom? Rights for the industry again. Okay. There is a 20% rebate on cess when they consumes less than specified water. There are certain water quantities that have been specified in the industry using less than that, there could be a rebate of 25%. Complying with all the standards, okay, then also they can get certain rebates. And then if the industry feels there is some injustice, or industry feels they have been wrongly charged when it came to the water cess or the water levy or the water tax, then they can make an appeal and get the redressal. Okay, quickly to indicate as to what are the industries which comes into the category of the Water Cess Act, or where the Water Cess Act will be available. In fact, all kinds of major industries, as you can see as I put the arrow down, okay, all the industries come under the Water Cess Act. So it could be ferrous industry, non-ferrous mining, ore processing, petroleum, petrochemicals, chemical industries, ceramic, cement, the textile industries, and in fact this list is even bigger. Okay, pulp and paper, and then you can say almost, it pretty much covers almost all kinds of industry. Well, quickly as to what kind of charges we are talking when it comes to the water cess. Here, for example, depending on what is the purpose of water that is being used for, as you can see here the heading, purpose for which water is consumed. Suppose the industrial cooling. In fact, the cooling water generally do not get so much polluted. What it really happens is it's a temperature that goes up of the water. So for example, if you're using the cooling water, the rate of cess, okay, will be around, or will be rather 1.5 paisa per kiloliter. That will be the charge. The interesting part about the laws is that laws can keep on changing. So we have to keep abreast with the change in the laws, we have to keep updated with the laws, and so it is not the science, of course the science also change with time, but the laws can change very quickly. So for example, I mean let's take this situation, okay, it's just the example to demonstrate certain thing, not that we are trying to actually do the calculation. Well, let's take the simple example here. Okay, suppose okay, let's do this thing. Suppose there is a steel plant, and the capacity of the steel, I write here capacity is, let's say, 10 million ton annual capacity of steel production. So capacity is 10 million ton per year. Okay, and is using the water for cooling, let's say. Okay, it's just an example that I'm generating an example for you, is using 100 meter cube. Meter cube is same as kiloliter per ton of steel. So cess, or the tax that industry will pay, will be equal to, for the cooling water, how much is 1.5 paisa So in terms of rupees, it will be 0.015 times how much water they are using, 100 meter cube or 100 kiloliters per ton. How much tons they are making? 10 into 10 to the power 6 or the billion ton. So this actually will, I'll make this one clear to indicate that this is actually 5. So let's not get confused. Okay, so this comes out to be number which will be, if you show the calculation, 3 digits will go away from here. So you have 3, 4, 5, 6, 7. Okay, so 1, 5. So this will be, in fact, this will be nearly 1.5 crore rupees. It's a big amount. So industry would rather make sure that it is using less and less water. So these are the charges, or these are the cess money or the tax or levy that one can calculate, and that the industry has to pay. So obviously, if there is so much money that industry need to pay, they would rather control, minimize the sources, minimize the water uses, and then save the money, because after all, it's all the economics that drives the operation of the industry. So it is in fact makes sense. It is rather useful to minimize the water uses and save money, isn't it? So these calculations can be done, and this column is another one here, the heading here. People will pay more, okay, and then you see star here and the footnote here underneath the table. The rate shall be applicable only in case of the non-compliance, because there could be other laws, other conditions. Suppose they are not meeting those conditions, then the charges would even go up. As you can see, from 1.5 paisa, this can become 2 1/4 paisa. Okay, that's a lot of money actually when we do the real calculations. Well, let's there are more information as to how much is the quantity of water that could one use, okay, and the amount depending on the process industry, the 20 cubic meter per ton. Well, we took the higher number in our calculation, 100 cubic meters, but that is the limit. Okay. Well, let's have the further. These again different kind of industries. This all information is available in the laws, in the published documents from the Ministry of Environment and Forest and from the Central Pollution Control Board. Just we want to quickly go over this so that there is a little feel as to what kind of charges are levied depending on what industry is in operation. Okay, there's another thing now. Again, staying with the environmental laws, there is another duty or another provisions in the Act that the government has to develop the water quality criteria that becomes for the protection of the public health, protection of the ecology, similarly air quality standards, noise levels. Okay, CRZ is a very coastal regulation zone in which the coastal waters are protected. Similarly about the sea water quality. So here the certain norms must be specified so that people know, are these norms being met with, are the people getting the desired or required water quality, air quality, noise quality, and also the regulations that become very important when it comes to the development of the coastal areas. This slide you see again for the water uses. What the Central Pollution Control Board has done is the water of the rivers, okay, has been classified in 5 categories, A, B, C, D, E. These categories refer to the what are the water uses or the best water use that water available in the river can be put to. For example, if you have very high quality of the water, okay, or you wish to have the high quality of water, so designated best use will be the drinking without conventional TR stands for treatment, but after disinfection. The water quality is so good that you don't need to do any treatment, just do some disinfection, maybe chlorination or ozonation, and one can use the water. So that is category A, B, C, D and E. So what the Central Pollution Control Board has done is classified the rivers depending on the classes, okay, depending on what kind of water quality they want. For example, we want to maintain a water quality in certain stretch of the river or the entire stretch of the river which is healthy for the bathing, okay. It's in our culture, it's in our ethos for the mass bathing the river. That's very religiously very important for us. So bathing quality of the river must be maintained almost in all rivers. So that's in order for having the water to be of the quality that one person can go and take bath. So what is that quality? So these qualities are defined. That becomes in the next slide. So for example, bathing, because we will not have the time to go through all the details here. So DO stands for dissolved oxygen. It should be more than or equal to 5 milligrams per liter. BOD, which is indicator of organic pollution, should be less than or equal to 3 milligrams per liter. Coliform, MPN stands for most probable number. Coliform is indicating of bacteriological pollution. So the coliform number count should be less than 500 per 100 ml. And then the pH, which is again you all will recall from your high school time, pH shows the acidity, alkalinity of the water in the broad sense. I mean, so or essentially it shows the hydrogen ion concentration that you will recall. I'm sure you recall pH is log of Hn concentration. Log is to the base 10 and H is the concentration, H plus is the concentration of H ions when expressed in moles per liter. Okay. Similarly, the water quality requirement will not be so stringent if the purpose of the river or purpose of the water is for the irrigation, cooling and controlled waste disposal. But however, as I again say, environmental laws are not the fixed entities, they keep on changing. So we should always keep ourselves updated with the environmental laws. In fact, these laws are also being revised and being changed. So how the pollution control is being planned or is planned is that, for example, this is some river that is flowing here, and suppose this is in fact this is the river Yamuna. Here you see here the quality of the water is E actual and the desired is C. So that way we can very quickly understand where and how the problem exists, because this is what is the desired, okay, use classified, or as you can see the desired, and here is the red line what you see is the E category, as we defined last time, is actual. For example, this is a little old slide, we don't know what actual situation is right now, but this is from the water quality profile of river Yamuna. So you can see very quickly with these maps we can find out what are the actual levels and what are the desired levels, and the difference or the gap between the actual level and the desired level is indicative as to what we need to do and what we need to improve. Well, let's still environmental laws don't end there. The Air Act came in 1981, okay, for the control of air pollution. Again, it was very similar to the Water Act, but the water in fact is replaced by air. Again, it needed control, abate and prevent air pollution to preserve and restore the national air quality, set air quality standards and criteria, and the noise pollution control or noise pollution is part of the Air Act that came through an amendment. Again, polluters pay principle, command and control and other pipe treatment that is being talked about in the Air Act. Responsibilities very similar to the air, similar to Water Act, consent to establish, consent to operate and the renewal of the consent. So they are the very similar kind of concept here when it came to the air pollution. Well, we will skip this slide. But in spite of having these laws, what happened, a very tragic thing happened in India was on the night of 2nd December in the morning of 3rd December in Bhopal, and that was the Bhopal gas tragedy took place, and that it caused very serious problem, and it was almost the entire country was shocked with such an industrial accident. So in fact, more than 400 people were dead, hundreds and thousands were injured, and the country was shocked. And then it was realized, well, we have the Water Act, we have the Air Act, and yet something of this size and dimension can happen. So, and then one more accident which is reported was in December 4, 1985. It happened in New Delhi. There was a widespread panic, that was for sure. And then this resulted in that we need to change the laws, and the laws keep on changing depending on the need and the situation or the demand from the people for the cleaner environment. So this law was most comprehensive and powerful act came in 1986. In this law, the implementing authorities had the powers for the closure order, ban on the raw material supply, and the focus is slightly shifted from just water and air to the hazardous waste, because hazardous waste can cause serious problem within a short time. Okay, management and handling, it become focus on manufacture, storage, and import of hazardous chemicals. Okay, because well, these chemicals could be, some of the chemicals are so hazardous that if they come in the environment, they can certainly cause serious problem, and even the deaths, and death are not one but several people. So the focus became this one. The another important thing came out of this Environmental Protection Act is the environmental clearance procedures, okay, and for the new projects, and that is called EIA requirements. So to briefly we'll discuss some of these the rules or the new legal provisions that came out of the Environmental Protection Act. So let's see some of them. The first, one of the important legislation that kind of is an offshoot of the Environmental Protection Act is the manufacture, storage, and import of hazardous chemicals. The Act also defines the things, what are the extremely toxic chemicals, what are the highly toxic chemicals, and they are decided on the basis of certain parameters called LD50. Okay, what is LD50 really is? It stands for lethal dose at which, lethal dose of the chemical at which 50% of test animals, they are mostly fishes. There are certain kind of fishes that can be used for this kind of test will die. Okay, so that decides the well, we should not only say here die in a specified time. So that decides the how toxic and how difficult from the environmental point of view the chemical is. You can quickly see this thing again, and in fact, depending on the, it's not only just the toxicity, it could be flammability of the chemical that could be important. There are certain explosive chemicals, they can be that comes under the ambit of this act. In fact, the documents concerning this law, this rule, the rules list 434 chemicals and specify the quantity that can be stored. Okay, just for example, this is one of the examples is there. So if you don't store much and you have to store it with the proper precautions, proper care, then you can store. But again, you can't store more than specified quantity, so that like even if suppose by chance there is some accident, the dimension of the problem will not be so severe and it will be manageable, it will be one can tackle it with the efforts and with the facilities available well within the plant. So, still staying with the chemical rules, okay, what are the obligations? What industry need to do is to identify the major accidents, what could happen, hazards related to the industrial activity, to provide relevant information to the persons liable to be affected. Suppose a large industry near some colony or where the people are living, is obligatory for the industry to specify and say, well, they are operating such and such process, they are using such and such chemicals which are toxic and can cause the problem. Safety sheets need to be maintained and label the specified information on every container of hazardous chemicals. So, we know exactly what is stored in case of the accident, in case of a situation which is untoward or some difficult situation, we know what kind of chemical is stored and what needs to be done quickly to minimize its impact. Responsibilities for the industry, safety reports, they have to maintain both off-site and on-site, prepare up-to-date on-site emergency plan in case things go wrong, maintain records of the imports of the hazardous chemicals, ensure transportation of hazardous substance as per the provisions of the Motor Vehicle Act of 1988. There are ways in which the hazardous chemicals can be transported and that must be followed properly. Similarly, there are the rules for the waste management, hazardous waste. See, earlier what we were talking about the hazardous chemicals and here what we are talking is the hazardous waste. Obtain the authorization for handling the hazardous waste from the authorities, apply for renewal of the authorization if the authorization expires, maintain records of hazardous waste handling and amount that is generated, submit annual returns. The way you file your income tax return and you are operating an industry, you better file the return on the amount of the hazardous waste that is generated and all other information that is required. Report to Pollution Control Board any accident at the site or during transportation, that is very important. Import of the hazardous waste to follow specific procedures. So, that need to be followed. You just can't import the hazardous waste that is for the reprocessing from another countries here. So, that also has certain procedures that need to be followed. Okay, what are the rights for the industry? Is an authorization for a period of 2 years is generally given, but this is not always guaranteed. Opportunity for hearing, state government to identify the sites for the disposal of the hazardous waste, because hazardous waste needs to be disposed of properly, and of course, as per the other laws, the right to appeal to the authorities. So, waste categories have been defined. Okay, the category 1, 2 to 18 categories have been defined, and what it really means. Category 1 is the category in which the cyanide waste is there, category 2 metal finishing, waste containing water soluble heavy metals and all. So, you can see that depending on what category, there is a certain amount of the regulatory quantities that one can handle and one can produce and dispose of. So, again that is driven and that is decided by the law. So, the laws have become very stringent now with time and constantly changing. I say it again and again because no law is fixed. There is another law which again industry need to follow, is the Public Liability Insurance Act that came in 1991. What is the purpose is that every industry need to buy an insurance. It is something similar to you are driving a car and you need to buy an insurance, because you can injure, you can meet with the accident and you need to pay someone you injure, because of you somebody got injured, then you need to pay, then insurance company can pay. So, you have to buy out an insurance. So, the idea was to provide relief, okay, to provide relief as specified in case of death or injury to any person or damage to property from an accident occurring while handling a specified hazardous substance. So, that there is some form the money is available. Of course, I mean one should take every effort that no accident occurs, but in case if there is, there should be a proper mechanism to quickly provide a relief to the people. Okay. So, that comes the mechanism here. And then to draw the insurance policies by the industry more than the paid up capital of undertaking, but less than 50 crore rupees. Let us read it again. To draw insurance policies which could be more than paid up capital of undertaking, but should be equal to the paid up capital, or but it should be less than 50 crore rupees. So, you buy the insurance, and obviously to pay the amount of an award as specified by the district magistrate and collector in case if there is an accident, in case somebody suffered because of the accident that took place in the industry. Obviously, the idea here is to that money be available in case of emergency, but you will see here as we can understand this concept as we are driving the car, and then we become very careful, because we know that if we make an accident we will cause more problem in terms of insurance will go up. So, you better be careful and not cause an accident. Similarly, the industry also is under pressure in a way to perform better, so that their insurance policies or insurance installments do not go up. Very important act and very useful act. So, there are certain the rights opportunity of hearing by the district collector before awarding the amount of relief to the people who suffered because of the accident, opportunities to file objections against the proposed directions in the specified form within a specified time. So, industry also can make an appeal and look for the redressal. There is also a requirement that every industry must submit an environmental statement by September 30 to State Pollution Control Board. What it needs to specify: the water and raw material consumption quantities, the pollution discharges in terms of water and air, hazardous waste information, solid waste, waste characteristics, and measures taken to prevent natural resources. Okay, another important legislation that have come into, and that is again offshoot of Environmental Protection Act of 1986, is the biomedical waste. Okay. What one would realize is the hospitals, okay, whether it's the human hospital or the veterinary hospitals, they generate a lot of wastewater. They generate a lot of waste, and that needs to be disposed. This waste can be very harmful because it could be infectious waste, and that can cause serious problem. So, for that again there are certain laws. The waste can be generated during the diagnostic, during the treatment, during the immunization, and on the animal research, and that waste needs to be disposed of. And there could be waste coming from the hospital, the shops, the doctors or the surgeons use the tools for surgery. That could be soiled waste, there could be other disposable, there could be anatomic waste, there will be some cultures, discarded medicines, some medicines expired and that needs to be discarded, there could be some body parts that need to be discarded, and that all become biomedical waste, and there has to be the laws and rules to handle the biomedical waste. So, biomedical waste also for the purpose of the implementation has been categorized into certain categories, and some of the categories are specified as you see on your screen. Okay, is the human and anatomic waste is one category, animal waste is a second kind of category, microbiological or biotechnological waste is another category, waste that is sharp like the knives and the other tools which the surgeon use, because at some point those need to be disposed of. So, what is the most important thing is that you do not want to mix these waste. Mix? No. Okay. So, then if you do not mix, then you segregate it. That is what is the law says. Segregate, and in order for not to having any confusion, segregate in the bags which are of different colors. Okay. So, that one would know where this waste is coming from. And especially see the other issue with the biomedical waste is, suppose there is some infectious waste. So, if you mix that waste with other waste, all other waste will become infectious, and people who are handling the waste or the people being disposed of on the landfill side or the rag pickers can pick up certain things, and they can get the disease because of the biomedical waste that is spreading around. So, there is a need to proper collection, proper treatment, and then the proper disposal. So, what are the ways and means to handle the biomedical waste? There is incineration, certain amount of the waste which can be burnt simply. There are certain waste which could be disinfected, and then disinfected waste can be mixed with the municipal waste. Then there is no fear of getting the infection from the biomedical waste. Then again, all the hospitals, large hospitals, must obtain a authorization from the State Pollution Control Board, and they must follow the rules and regulation specified for the biomedical waste rule. This has become very important, and almost all the hospitals in the country are now following the biomedical waste rules, and it is very important for our public health, for the people at large, that no infectious waste comes out from the hospitals, and it does not cause any other serious problem for the people who are handling the waste or the people at large. Okay, there is another very powerful means for the pollution control in the country is called public interest litigation. I am sure you all hear this in the newspaper, and the actions being taken by the courts, and what it says. In fact, the Supreme Court of India has expanded the scope of the boundaries of the fundamental right of life and personal liberty as guaranteed in Article 21 of the Constitution of India. So, the guarantee which the Constitution gives to us for the personal liberty and right of life is simply not just live, the life, right to life with the proper environment and the clean environment. So, if in some sense, if this fundamental right is infringed with, then there has to be some action mechanism that is put into place, and that comes through public interest litigation. The court has interpreted the right of life, okay, and personal liberty to include the right to a wholesome environment or the clean and the proper environment. If suppose that environment is not clean, it means in a way the court can interpret this as the infringement, okay, of the fundamental right to live in personal liberty, which is very strong and powerful interpretation our courts have given, and that in fact has kind of stimulated the general people at large, and many public interest litigations have been filed, and it has resulted in clean environment, many of the cleaner process. In fact, we have some of the examples, as you can see here. Some of the important PILs are the gas leak from the Shriram food fertilizers in Delhi in 1985, that became the subject of PIL. H-acid industry in Udaipur, air polluting industries in West Bengal, including some of the oil refineries. Hazardous industries in Delhi became the PIL because people thought if there is hazardous industry, it could be harmful and it could be dangerous. Common effluent treatment plants in Delhi, H-acid industry in Ratlam. Many PILs are filed in Taj in Agra to protect the Taj, and many other things. Example you see here, that has resulted in very quick decisions, and it has the people have become very active and participating in the PILs, and that could lead to a very healthy and very good environment.